So, welcome back to our IP channel, and today we are going to introduce you to industrial property rights.
Industrial property rights? What use and role do they play? How does it work?
If a person has an idea, they need to protect it, and industrial property rights are part of intellectual property. It includes patents, trademarks, industrial design, and geographical indication. These rights allow the creator to earn recognition or financial benefit for their work without having to worry about others regretting and gaining advantage from it. And you see, this is the case if we wouldn't apply the exclusive right to our creation. Someone would steal it and use it for their financial benefit. But due to granted rights, we can protect ourselves.
Wow, I had no idea. Sounds like it would be worth to apply for. But wait, how do I protect my intellectual property?
No worry, I will explain you the four concepts. Starting off with patents, almost everyone has heard of patents. It is the most common known right among the public, and it is an exclusive right that is granted to an invention. It provides exclusive right for our commercial exploitation of your invention. And by registering a patent, the invention cannot be disclosed to the public until resolution and leaving time for improvement. And to register, you need to fulfill the following situation: be new, be inventive, and be capable of industrial application.
By new, you mean something that has never been to the general public before, right?
Yes, of course.
Also, to be inventive, it must differ essentially from existing solutions, am I right?
Totally.
And the last one means that the creation should be able to manufacture it or used.
So, all right, so like you are an expert now.
Thanks to you. So now I have fulfilled every criteria. My criterion is successfully registered.
However, not so fast. There are more options than just patents. Let's take a closer look at industrial design rights. It is an exclusive right used for protection of new forms of body, picture, drawing, contours, composition of colors, or a combination of the feature designs. And industrial design cannot be applied to protect the appearance of the creation, not its functionality.
But why would there be a special right for design?
So, because the goal is to encourage new design and to support those who are prepared to invest in design. Important side note: protection can apply to the whole product or just parts of it.
Awesome. I didn't know that before.
Another way to protect your creation is to trademark it.
I have heard about it, but what is a trademark?
Trademark is a sign protected by exclusive right and distinguishes the product or service of its holder from those of others. In case of businesses, customers know a company by its trademark, which is often an important part of its brand.
Does that mean that my words, names, slogans, numbers, letters, drawings, logos, and all of that are protected?
Yes, it does.
Good to know. Okay, now I know a lot about patents, industrial design, and trademarks. Is there anything else I need to know?
One last thing, application of origin and geographical indication. It is used to determine origin and quality of a product.
When can I use it?
It can be used by own producers where product originates from the designated place.
So that's how it works.
And that is how it works.
Can I apply for those rights with any idea or product?
I'm afraid it is not that easy. Your invention has to fulfill some criterion first. The question should be associated with production and business activities, and only protected when protection title is granted by state agencies, and protection validity is based on the term of the protection title.
Sounds complicated. Can you explain it further for me?
Yes, I would love to. Let's take a close look at the first criteria. To fulfill this principle, your invention must be useful and highly applicable, and in particular, the condition for protection of inventions, industrial designs, and layout design is that product must have the capability in the field of science and technology. And the purpose is to create products of practical value for human life. As for trademarks, trade names, geographical indication, and business secret, they must contain commercial indication. And furthermore, as the second criteria comply, your question can be protected when the title is actually granted by a state agency. Remember, registration is only mandatory, but not registering your invention lead to losing your exclusivity. And the last criterion is about validity of the protection. Properties protected by terms are those whose creators can be identified. Industrial property with unidentified creative authors are protected for an indefinite terms or for a term with certain conditions.
I can see how there are different terms. The term of protection is determined and cannot be extended. The term of protection is determined and can be extended. The term of protection is indefinite. That was a lot of information, but I still don't understand what role they play during business practices.
This is an easy question, so let me answer them for you. First, we want to protect our businesses against unfair competition practice. And second, we want to protect our core value of business and create greater value. And lastly, we want to promote fair development to create a highly competitive business market.
Wow, after hearing all of this information, I finally understand what industrial property rights are about. Thank you so much, Hui.
You are welcome and thanks for paying attention. And for you guys out there, don't forget to protect our idea.